Good afternoon and welcome to the Public Service Commission of South Carolina. It is 2:32 and we are here continuing with interviews for the proceeding in docket number 2022-104-E, which is the Public Service Commission's request for a proposal of consultants and experts related to the 2022 competitive procurement of renewable energy proceeding to be filed by the South Carolina Public Service Authority, also known as Santee Cooper, in compliance with South Carolina Code Section 58-31-227. And we are here for the interview with PA Consulting Group, who submitted a response to the request for proposal. Before we get started, let's take a roll call of commissioners who are present or attending virtually. Present in the hearing room, we have Commissioner Justin Williams, Commissioner Thomas, and Chair Belser. Attending virtually, we have Commissioner Irvin, Vice Chair Powers, Commissioner Caston, and Commissioner Carol Lee Williams. And present in the hearing room, we have a representative from PA Consulting Group. Mr. Hasbrook, Derek Hasbrook, is attending in person to explain the RF. Mr. Hasbrook, I need you to turn your microphone on. There's a button at the bottom. There you go. You may have to get a little closer to it. You have to almost eat these microphones. And
Derek Hasbrook, how does that sound?
That sounds a lot better. And we do have a court reporter present who is taking down information. And then I'm going to recognize you, and you can introduce your team and any preliminary matters that you may have.
Thank you, Commissioner. Thanks to all the commissioners for having us here. PA Consulting Group is delighted to be here. We are a 3,500 person global consulting firm. We're headquartered in London, England. And have offices here in the States in Boston, New York, Cincinnati, Chicago, Atlanta, Denver, and San Francisco. And you'll hear folks from several of those offices on our team today. We've brought with us the full team that we anticipate working on this engagement, perhaps but for one junior member. And our intent is to have you get to hear and speak with all of our team along those lines. Our goal is to be the leading advisor to the clean energy transformation in this country. So the opportunity to advise the Commission on a large large renewable procurement that is the first one supervised by this Commission is a very exciting opportunity, and so we are delighted to be here and be considered for this assignment. Myself, the gray hair basically means I've been around a long time, but I've had the pleasure of working for nearly 100 utilities across the country over the last 40 years in a wide variety of capacities. I've testified before 15 or so regulatory bodies in the U.S. and Canada on, again, a variety of utility matters. I currently lead our independent evaluation team at PA within our energy practice, and I'm here in that capacity as we believe this assignment, while not the full scope of what is often considered an independent evaluator, is very similar to that, and we've got that team here for you today. With that, I'd like to turn it over to our team that is attending virtually to introduce themselves, starting with our proposed assignment manager, Martin Szczepanik.
Great. Thank you, Commissioner. Thank you. My name is Martin Szczepanik. I've been in the energy and utility industry for about 8 years now, and I would be the assignment manager, so the person responsible for managing the assignment on our side. I have a lot of experience in independent evaluation work. So prior to PA Consulting, I was with Guidehouse for 3 years. I served as the independent evaluator for Excel, Northern States Power, Sherco Solar proposal a couple of years ago. served for Arizona Public Service in their all source procurement about a year and a half ago, and served for DTE both on a small scale and large scale procurement. I'm really looking forward to working with this commission. You probably recognize me because I've been on the 2 previous calls as well. And with that, I'll turn it over to my colleague, Charles Janisek.
Great, thank you, Martin. Good afternoon, Commission. This is Charles Janisek. Good to see you all. I've got about 25 years experience where advising utilities in different matters, including 6 years at a utility at Xcel Energy in their resource planning department. For about the last 8 years or so, I've focused largely on resource planning and procurement support services. I've done a lot of procurement support for Xcel Energy, for PacifiCorp, engaged currently for PacifiCorp, providing independent evaluator services for their all source RFP that is currently ongoing. Also, I've done a lot of procurement support for PG&E and San Diego Gas and Electric, overseeing their capacity and all source procurements, renewable procurements for them. Looking forward to potentially working with the Commission on this procurement support with Santee Cooper. We're pretty familiar with Santee Cooper, as you know, from our prior work, not for Santee Cooper, but looking into Santee Cooper itself. And yeah, at this point, I can turn it over to my colleague, Sarah.
Thank you, Charles, and thank you, Commissioners. My name is Sarah Bethel. I'm relatively new to PA, but have been in the energy industry for nearly a decade, starting out on the developer side and then working for a publicly owned utility as a resource planner. The last several years, I've been in consulting, focusing on integrated resource planning, as well as regulatory and policy interpretation, where I will serve as regulatory assistant for this potential engagement. And I also have independent evaluator experience working in the state of California for the commission there for interconnection program adherence, as well as wildfire mitigation on another side of things. Thank you. I will lead into introducing Jonathan Jacobs.
Thank you, Sarah. My name is Jonathan Jacobs. I have been an independent evaluator of resource procurement for a number of years. I've actually been in the electricity business for over 30 years, starting with Pacific Gas and Electric Company, a public utility, and PG&E Energy Services, an unregulated gas and electricity marketing company. I've been a consultant with PA Consulting Group for almost 22 years now. I've been an independent evaluator for San Diego Gas and Electric, for Pacific Gas and Electric, for PacifiCorp, and through my independent evaluator work, I have also been an expert, or as a consequence of my independent evaluator work, I've also been engaged as an expert witness on capacity contracting in arbitrations and in regulatory context. I also work with system operators on the systems and processes they use to dispatch and price power. And I'm going to turn it over next to Jim Heidel.
Good afternoon, Commissioners. This is Jim Heidel. Not trying to compete with John. I think I've been working in the energy business and utilities for about 40 years now. I've been working both in industry and as a consultant. Perhaps most relevant is over the last 3 or plus years, I've worked for the advocacy staff of the North Dakota Public Service Commission and working on applications by 3 different investor-owned utilities for new resources, so evaluate those resources, including the process that they use to come to their selection of the resources they're seeking approval for. And I've testified on behalf of the advocacy staff of the Commission multiple times. And with that, I would like to turn it over to Rachel Bryant.
My name is Rachel Bryant. I apologize, I'm having technical difficulties with my camera, so forgive that. But my background is as an engineer. I worked in Houston, Texas for a while within the petro oil fields and got a lot of experience there. But most recently, I have about 12 years of experience working as a federal government attorney. I've worked for both Department of Energy and FERC. and have represented them in various proceedings, including the recent move for WAPA, the Western Area Power Administration, to join SPP. So I'm well versed in a lot of the proceedings and assisting with expert witness testimony and other support. Worked with Jim closely in a lot of the different efforts that he mentioned, and I'm looking forward to providing advisory during this obligation as well. Look forward to meeting everyone. Thank you for including me.
And commissioners, that is our team, and hopefully we'll hear from each of them in appropriate places as we go through the questions.
Mr. Hasbrook, I forget the mic too, so, Mr. Hasbrook, do you have a presentation that you want to do?
We do not have a presentation. We will file the written answers that we have to these questions, but our thought was to just sort of walk through them in order, if that would
that'll be fine, and that would be fine. And I'm going to ask you to kind of lead that, going through the questions, and call on your team members as you may see fit.
That sounds great. Subject to the momentary frustration of my computer timing out. So
now, if commissioners have questions during responses, may we ask them then, or do you prefer that we wait till the end?
We would very much prefer this to be a dialogue. So the moment you have a question, please interrupt, or whatever way of grabbing some airspace is the easiest and best. I think that's the most productive for everyone.
Thank you, sir.
So hopefully that's a brief introduction to our firm and our team. As far as having appeared before the Public Service Commission of South Carolina in the past, several of the team members you've just heard have appeared in the recent past in similar bid presentation situations around the avoided cost filings for Dominion, Progress, and Duke, and then others around the IRP solicitation for Santee Cooper. Jonathan Jacobs and I have never had the pleasure of appearing here, and I don't believe anyone on our team or at PA has had the pleasure of appearing before the commission in a active matter. Have you ever been employed or retained as a consultant by the South Carolina Public Service Authority, aka Santee Cooper, or any of its affiliates? PA is not currently engaged with Santee Cooper, and to the best of my knowledge, has not done any work for PA has never done any work for Santee Cooper. Prior to my firm, a firm I was with, being acquired by PA in 2000, I had done some work for Santee Cooper in the 1990 timeframe. If Ken Ford rings any bells to anyone, it's going back that far. So that is what we can say there. Charles Janicek, when he worked for a prior employer, did work for Santee Cooper on their IRP in 2015, but obviously at this juncture has no access to any of those files or information, etc. And I'm just going to pause a moment at the end of each of these, so to make it easy to interrupt. Have you or your employees, associates, contractors, or partners ever been retained to represent Santee Cooper or investor-owned public utilities in South Carolina? No is the short answer to that, and I guess I'm going to add on to that. In a number of places here, the question said public utilities. We've generally interpreted that to mean investor-owned utilities in South Carolina. We work broadly that. We work for a lot of utilities all across the country. So if the intention is, if you're interested in a more broad statement of who our clients are or to any of these questions, please just ask. Your immediate, and I should say all of us are employees of PA Consulting. There's no subcontracting on our team or any other arrangements other than straight employees. Do you or any of your members, family members, own any bonds in Santee Cooper? No one on our team owns any bonds in Santee Cooper, and we're not aware of anyone across PA. But honestly, we don't have a mechanism in place to track that necessarily. Do you have any reason to believe you cannot serve as a fair, impartial, or independent consultant in this docket? Absolutely not. We wouldn't be here if we had any concerns on that matter. This independent evaluator team specializes in doing that. Do you have any ongoing business dealings with the parties in this docket? If so, what are they? We do not have any ongoing business dealings with Santee Cooper or the commission, obviously. To the extent that the docket might eventually include parties that have bid into Santee Cooper's RFP, we will not be doing any work, obviously, that would support any of those bids. But that's a bit of an unknown of sort of would parties show up. So don't know the full answer to that at this juncture, obviously. Are you currently in any negotiations to represent any parties before the Public Service Commission? Straight answer, that's no. Do you hold any licenses, degrees, designations, or credentials that qualify you as an expert in this field of electric utility matters? Our team includes a spectrum of engineers, economists, mathematicians, and attorneys. I myself am an engineer with an MBA. One of our other engineers is a chartered financial accountant. Jonathan Jacobs is a PhD and former Jeopardy champion. So that goes to all sorts of important things. And Rachel, as she indicated, has a Juris Doctorate, but is not currently a practicing attorney. Are you a member of any utility-related trade groups or organizations? If so, which are those? We have memberships in the American Gas Association, the American Association of Appraisers, Western Energy Institute, the United Kingdom Nuclear Industry Association, A Word About Wind, Westminster Energy Forum, Association of Women in Water, Energy, and the Environment, the Women's Energy Network, and certain of our other individuals may have personal memberships. I'm a member of the IEEE, for example. Can you provide final written proof of a conflicts check on your part? Absolutely. We understand that's expected on Thursday, I believe, and that is our intention. If you're hired as a consultant, will you be able to abstain from any unauthorized ex parte contact with current or future parties to this docket? Yes, we will. We have been learning about the ex parte rules as some of these and other discussions have gone along, and are growing in our understanding of those, and will certainly commit to follow them.
Mr. Hasbrook, over here. The ex parte contact also, even though you're a consultant for the commission, can also apply to contact with the commission where parties to the docket may have to be copied on correspondence to the commission with questions or scheduling or procedural things too. So that wouldn't create a problem, would it?
I don't believe so.
Okay, thank you.
Are you aware of any reason your firm should not serve as an independent expert in this docket? No. We've done, and I should have said earlier, we've done a preliminary conflict check, and we'll finalize that later this week. What's your schedule for completion of the project? and this goes to several of the following questions. I'll turn it over to Martin here for discussion of this, but we had been somewhat unclear as to the definitive scope that the commission was looking to tackle here. I think that has become much more clear to us in the last, much more clear to us. And what we now believe we understand is that Santee Cooper will be filing a proposed plan for its solicitation on or about the 1st of November. And the first step in this engagement would be to review that, do any further exploration, investigation into that that's appropriate, and then look to advise the commission on the appropriateness of that plan, the completeness of that plan, the consistency of that plan with the South Carolina statutes and best practices in the industry for doing that. In that context, we think of that as probably a 120-day kind of schedule, but it can probably be accelerated if the parties need to, but it's something along that order. Would it be all right if I asked a question at
Sure.
this juncture?
I may not be able to answer it, but you may ask.
Fair, more than fair. Does the commission envision issuing an order approving, if you will, and I use that word hesitantly, Santee Cooper's plan, or does it envision accepting it, sort of as before it is put on the street? Is the commission looking to take a proactive step, or just sort of accepting it at some juncture, perhaps as modified, or?
The commission speaks through its orders, so there will be some order that has to be issued. And so whether that is accepting, asking for modifications, I don't know. There's a range of things that the commission could do, but there will have to be an order issued in some capacity. I'm not predetermining anything. It may be approve it, accept it, or request modifications, or deny it and try again. I don't know, but it's got to be something, and we can only do that through order. So yes, there will be an order issued.
That was our understanding, but appreciate that commentary. Thank you. Martin, I know I've taken I've commented a bit on the schedule, but perhaps is there anything else you'd like to add to get to the schedule?
No, nothing really too much in addition. We do also, if the commission sees this as an option, not only reviewing the upfront, the report or the plan that's created by Santee Cooper, but then also supporting the commission on an ad hoc basis as Santee Cooper actually executes the procurement. So we did get this new information just now, and appreciate the clarification from the commission. We did not include a schedule or our hours and total fees, but we did include an average hourly rate in our original proposal. So if it's okay for the commission with this additional information and additional information as we get through the remainder of the interview, we would like to file additional information with the commission to provide us with our schedule of completion as well as our projected total fees and hours.
That can be worked out. We would just ask that any amendments to pricing or hours or any of that be filed with the final conflicts letter on Thursday, if that's doable.
That is makes complete sense. We will do so. We will do so. So with that, I think we've covered estimated hours per task and total estimated hours, total estimated cost. Martin, relative to the requirements of South Carolina Code 58-31-227, is there information? What information does the commission need to receive from us?
As far as we know, there's no information. As far as we understand that this is all information that Santee Cooper needs in terms of executing their procurement in accordance with the law. So we would be using this information as part of our assessment process. But in terms of what's needed from us, we don't believe that this applies to us.
And I guess I just add to that just using the pro forma contract as an example. The expectation is that will be part of the plan. There's a requirement in the code that it be there. Our anticipation is that our report to you will say, yes, that's there, or no, that's not, or yes, it's there, and we would suggest these modifications to it, and that their schedule complies with their proposed schedule complies with the pre-announcements or that are also required in that section. So that's at least our understanding of how that would work. Do you or your firm contribute to political action committees? We are not a politically active firm. PA does not contribute to any PACs, and I am unaware of any individual contributions to PACs. Is there anyone who currently works for your organization who worked for a public utility or for Santee Cooper in the past? None of our team members have worked for Santee Cooper or South Carolina Public Utilities in the past. I'm a past Florida Power and Light employee. I'm a past Vermont Electric Power employee. Several of our team have been former employees of other utilities nationwide, but this was an example where we were assuming what you were really focused on was South Carolina. Is there anyone associated with your organization who has any affiliation with a public utility company or with Santee Cooper? Again, the same basic answer. We do not have anybody that's affiliated with Santee Cooper or with any of the South Carolina public utilities. We have a number of utilities nationally that we have a client relationship with, I guess, if that falls in the category of affiliation. Are you associated with any matters pending before the Public Service Commission of South Carolina now, or have you in the past? No, we do not have any matters pending, and we, to the best of my knowledge, have not had any involvement in previous matters here in the state of South Carolina.
This is for the attorneys section. And I believe you indicated that your counsel who's on your team is not currently practicing. Is that correct? I mean, you're free to you're welcome to answer these questions, but these are geared more toward attorneys who may.
So we had I didn't read my cues of where I was supposed to hand this off to Rachel. So thank you for your guidance, Madam Chair. Rachel Bryant's actually going to cover all 5 or 6 of these, again, in the context of a team member with significant legal training and legal experience, but not acting as counsel. Rachel, over to you.
Yeah, no problem. And we did understand that the target of these questions were for licensed attorneys, and we inferred as a team that was likely not applicable to us given the licensing status of those attorneys that we do have on staff. However, we still thought it was valuable to provide context and responses to some of the questions, as it might still go toward the validity of our team and our level of expertise, even though technically we would obviously not be representing the commission as an attorney. So we went ahead and answered them. So the first one that Derek just covered is we don't have any attorneys that are involved currently or prior with matters with the PSC of South Carolina. We do have 3 attorneys on staff. I'm the only one that is on this team, but all of us are licensed in Colorado, although as Derek mentioned, our licenses are inactive, which just protects PA and its own liabilities, as I'm sure other lawyers would certainly understand. We are all in good standing within the state and all have different reciprocity opportunities should we choose to explore them. Notably, however, as I mentioned, we're all currently in an active status to preserve that role of PA as a legal advisor, but not actually technically as an attorney. The question that we thought was relevant and helpful was, have you ever appeared before any PSC or Public Utilities Commission as the attorney of record? We have not, that to my knowledge, on our 3 attorneys. However, we have prepared expert witness testimony for use in PSC proceedings and have assisted with other preparation efforts. We have a litigation support practice as well as expert witness testimony support. So we're very well versed in all of those things. Sort of going to that mind, the next question, which is, have you ever worked for any PSC or Public Utilities Commission? No. Once again, as Derek mentioned, we have other staff members that have worked in different capacities within those organizations across our group. However, as I mentioned during my intro, I've worked for both FERC and Department of Energy, and as part of that work, I assisted with efforts to join SPP, which obviously involved extensive interaction with PSCs throughout the West. We also have people on this call and on the team who, while not in an attorney role, have certainly contributed in those types of efforts. And then the last question is, have you ever been disciplined by the state bar? And fortunately, no, I did do a thorough check just to make sure prior to answering this question, but none of the attorneys within PA have ever had any disciplinary action filed against them.
Thanks, Rachel, and colleagues. If I could remind us all, perhaps me at the front of the line, to be careful in our use of acronyms, because it feels comfortable as they roll off the tongue, but doesn't necessarily communicate fully. Rachel mentioned SPP, and it's the Southwest Power Pool, for if that is helpful. And obviously, when she mentioned DOE, that's the Federal Department of Energy. So with that, I think we can shift to the substantive questions. The first one is, have you ever consulted with a party concerning a competitive procurement of renewable energy? Charles, you want to take that one?
Yes, sure. Thank you, Derek. Yes, the answer is yes, we have. I personally have overseen the procurement of PacifiCorp's both 2020 all source and 2022 all source RFPs. And those are labeled all source. The fact of the current state of the industry today is that typically when we see all source procurements, we see them, sort of dominated by renewable energy bids and solutions. There may be some cases where there is non-renewable, say thermal energy bids into solicitations, but frankly, those are fast becoming the minority. And so in terms of PacifiCorp's all source, it has involved bids ranging from wind, solar power, wind plus storage, wind plus or solar plus storage, as well as pump storage hydro considerations as well. So very familiar with renewable energy procurements. The PG&E and San Diego Gas Electric work that we've done, those have ranged from relatively straightforward capacity solicitations, as well as other forms of generation, including specific renewable solicitations in the case of San Diego Gas. Also, our work with the advocacy staff of North Dakota Public Service Commission, those procurements, which we were advising staff on the prudency of the potential acquisitions, those procurements also have largely involved renewable energy, although there have been some thermal, natural gas fired resources that we've advised staff on as well, dating back to 2017. Going a little bit further back and getting to the next question, actually, I, with a former employer, was the independent administrator of a procurement for the utility out in the Commonwealth of the Northern Marinara Islands. And for that utility, for that effort, We designed the RFP, designed the procurement, administered it, took in the bids, evaluated the bids, and made a recommendation to the utilities board on what bids they should accept and which bids they should reject. The size of the procurements have ranged from 550 megawatts for the Northern Marinera utility. The Pacific Core, the need has ranged up above 2,000 megawatts. Bids have not come in yet for the Pacific Core 2022 all source, but in the 2020 all source, there were over 500 individual bids submitted to that procurement, and I would say well over 500 were specifically related to renewable energy as well. So I think that gives a flavor for our experience working with competitive procurement with renewable energy. But I will pause here to ask the commission if you have any questions.
Charles, I'll just add on for clarification. Pacific Core is a piece of Berkshire Hathaway Energy that serves parts of Washington State, Oregon, Wyoming, Utah, and I think a little bit of Idaho and a little bit of California. So their all source procurements are large and complex, and we've had the pleasure of working on behalf of the Oregon Public Service Commission in being the independent evaluator for those. So that's the context of that. So Charles touched on the size of the competitive procurement.
Chair Belcher, excuse me, this is
Commissioner Caston, please go ahead.
Had it on mute when I was asking the question before. I apologize. Relative to, I guess, the last response and thinking about the data, and I'm not sure who would answer this, but should Santee need a third party to aggregate that data, or is it common for utilities themselves to manage the data in-house? What is your experience, or what do you think is the best way to do that?
Yeah, thank you, Commissioner Caston. What I would say is utilities conduct these types of solicitations all the time. It sort of depends on, I would say, the experience level of the utility and how frequently they conduct these procurements, how prepared they are to get a very large number of bids. For example, fundamentally, there's no structural or any reason why they cannot. And I believe in the most recent procurement that Santee Cooper did, they worked with their main customer, Central Co-op, to do the analysis. And given that they've done that relatively recent, I don't see any reason why they would not be able to handle the data, handle that type of bid involvement for their upcoming procurement.
Thank you very much. I appreciate that.
Yes.
The one thing I could add there, Commissioner Caston, is there is a journey in sophistication here that individual utilities have undergone. So, for example, when Dr. Jacobs was talking about having served as an independent evaluator for San Diego Gas and Electric, I believe that dates back to 2006. The work we did, the work San Diego did, and the work we did as an independent evaluator of those procurements back in 2006, 7, 8 is quite a bit different than the work we do today for related to their procurements because of the evolution of the sophistication of their processes and capabilities, as well as the evolution of the market. Here with Santee, you've got a situation where, this is the first procurement that is under the supervision of the commission specifically. As Charles said, the prior one was done in seemingly, or at least reported to be done in conjunction with Central, which seems like a reasonable thing to do. But I think our general experience would be that the sophistication of this process will evolve over time. And I think one of the questions perhaps that for the commission to think a little bit about is where the public perception of truth and openness and transparency, sort of how one meets those general standards and objectives, where that fits in the current puzzle. So not a black and white answer, but it would not be uncommon for the first of a procurement to be done under the auspices of a regulatory commission to be perhaps subject to a bit more scrutiny than subsequent ones. So where that concept fits exactly in the journey we go on, I don't know.
Thank you. Very good.
So Charles, skipping a little bit out of order, but maybe just trying to build off that, that touched on what issues would Santee Cooper expect to see during the administration of its competitive procurement process, I think. Martin, do you want to just cover those points off to make sure for completeness, and then we'll circle back to a couple of the questions we've skipped over here?
Sure. Thank you, Derek. Yeah, so just the way that the question is worded, we don't necessarily expect to see issues, but I'm going to answer this in terms of common challenges that we see in executing successful procurement. So from our collective experience. So sometimes what we see is overly restrictive definitions of the resources that are being identified. And what this does is it limits competition. So fewer people bid into it. If you're overly restrictive, at least my understanding of Santee Cooper's procurements is that it's more a bucket of resources at this point in time, not necessarily saying X resource at Y location. So hopefully that's not going to be too big of a challenge. And what we see as a mitigation measure is making sure that when you define what the resources that you want to see are there, you look into the interconnection queues and actually are able to tell and able to see that there's enough there to support the need that you're going for. Number two is public scrutiny. So I know Derek touched on this, and making sure that there's public engagement, public stakeholder meetings, that they have an input into what the scoring criteria is. I know we have a question further down the line with which Dr. Jacobs is going to answer about equity, environmental justice, a couple of those other items that might be included in the scoring criteria. But really making sure that the public is aware of what's going on, that they're being engaged in these stakeholder meetings, and then they have a place to speak about any kind of concerns that they might have before the procurement is issued. Defining scoring criteria is always very challenging because it's not just the fact that you have a quantitative score and a qualitative score, but there's a lot of decisions that go into that qualitative scoring of what's important. Is it important to put the solar projects in economic development communities? Is it important to use a certain wage type? Are certain animal species, protecting them, important as well? So defining the scoring within that qualitative or criteria, it's difficult, but it also requires input from the general public too. So we think that that's interconnected with the last point. A couple of other things, just quickly mentioning, is volume of bids. So I know I've been in this situation, and I know some of my colleagues talked about it before, but with Arizona Public Service, the all source procurement that I did with them, we had over 600 iterations of bids that came in. That was a very open, very broad to any kind of resource. So it depends on how many resources available, how many different types of technologies you include, and kind of balancing out the overly restrictive definition of what resources you want versus being too loose, having a good middle ground to identify the right amount. And last but not least, bidder quality is very important. So I know we made a joke on a call earlier that we don't want anybody with a briefcase and a fax machine to be able to submit a bid and to get a project awarded. And one of the ways that we see this being handled is putting minimum scoring criteria up front and making sure that whoever is bidding into the proposal, bidding into the resource procurement, actually has relevant skills and experience and a backlog of projects that they've done before to prove that they're able to do it. So I know that that was a lot. That was rapid fire. So I'm happy to take a pause here and see if the commission has any questions.
Commissioners, any questions?
To move along, circling back, the question that I skipped over was, do you have any experience drafting data requests or discovery? If so, explain. I think, Jim, you're going to handle that one?
Yes, thank you. So just myself, as well as some of the other team members who worked with me, I'd say over the last few years, we've participated in approximately 10 proceedings representing the North Dakota Public Service Commission advocacy staff on resource procurements submitted by utilities. We're responsible for data requests. In addition, over the last few years, I've also worked on rate cases for Montana Dakota Utilities, Puget Sound Energy, Arizona Public Service, NV Energy. So we are very familiar with developing data requests, submitting data requests. In terms of my experience and the lessons learned is, one is I think it's very important to be polite and civil in the data request, but it's equally important to be specific as possible about what one is looking for so that the utility or other parties know what you're looking for and can provide it in a single pass. So that involves, whenever possible, referencing specific testimonies, specific data responses, lines, and just making it easy to identify what's exactly needed and where it's needed and what form it's needed. And that answers that question. Derek?
Thank you, Jim. Moving along, given the schedule and what you understand now about this work, please describe the work you would propose to do, the team members who would be responsible for it, their locations, etc. Martin, as proposed assignment manager, could you take that one?
Sure. Yeah, thank you very much. So the work that we do, and based off of the clarification that we got earlier, can really break it down into a couple of primary things. So looking at Santee Cooper's filing, assessing it against the requirements of Section 5831227, assessing it against our understanding of best practices, including EDGAR criteria, which we'll mention a little bit later on in our presentation, and then eventually providing a commission report or memo to support that directive that you'd be giving in the future. So really that's where we see the bulk of our work happening up front in terms of the review process. And I do believe that there's probably still a discussion to be had about ongoing review and ongoing evaluation of Santee Cooper's procurements. In the meantime, also, one important thing is for us to attend the any sort of presentations that Santee Cooper has in the meantime discussing their RFP. We know that's important because we want to make sure that there is public transparency and that any sort of comments and questions and the interaction with the public is incorporated into the RFP documents that they eventually develop. So we do think that's a critical importance. As far as the team members, pretty much everybody on this call would be supporting. We do have a couple of other analysts that would be helping us out with doing some of the more detailed work. But the team that you have here and see here is the bulk of us. Personally, I'm in New York City. I know Derek is on the East Coast as well, but we do have team members in California, Denver, and a couple of other places here too. So we've got representation across the U.S. As far as our specific competencies, so I believe we did touch on this, but we do have the independent evaluator, independent monitor. Different states call it different things. I've been independent observer, independent auditor, also on the consulting side for procurements. But broadly speaking, the procurement consulting work and the regulatorily filing work that Jim and Rachel are very well versed at, and Sarah's particular expertise in IRP, we thought it was important to bring those all together. And I believe that's all I have on this particular question. So Derek, I'm gonna throw it back to you unless there's any questions from the commission.
So with a little luck, I'll be back on in order now. So, question: do you recommend any caps or limitations on the competitive procurement of renewable energy bids? John?
Thanks, Derek. There are a couple of different types of caps or limitations which you might be referring to here. First of all, price caps. Limits, it's the reverse of a reserve price where you say we will only take prices above some level in an auction. You can also say we will only consider prices up to some level, or as an unstated criterion have a price cap on. That's particularly useful if you have a history of renewable bidding, or if you have a history of publicly available construction costs, or if you have experience with the construction and costing of renewable resources in multiple jurisdictions, which some of our colleagues who are not independent evaluators have. We have experience with independent evaluation of projects in a number of jurisdictions. The firm as a whole has wider experience that we may or may not be able to take advantage of depending on the nature of the bids. Or that one may or may not be able to take advantage of depending on our ability to control the conflicts. Secondly, there could be a limitation on the total capacity that you accept from the solicitation or from an RFO. Sometimes utilities will solicit openly through a feed-in tariff, where they will basically take any capacity that comes to them meeting certain criteria up to a particular limit. Other cases where you do an open solicitation, actually compare the bids, you get a much better chance of getting the less expensive and better bids. In that case, the utility will normally define for their selection criterion a margin above their actual need, however many megawatts of renewable resources they really think they need in a particular year. They will initially solicit or accept bids from more than that capacity in order to allow for the fact that they won't necessarily be able to come to contract with anybody, or some of these projects will fall off during the construction period. They will have some sort of off-ramps to take care of that. So those are the types of limitations or caps that you want to apply or may want to apply. The next question: have you ever participated in or acted as an independent administrator for a competitive procurement of renewable energy program? Charles addressed already his own experience as an independent administrator in the Northern Marianas. In addition, we have administered transmission solicitation for Transwest Express, and we think that, so we have been both an independent evaluator and an independent administrator. The next question has to do with the guidelines or best practices that would you suggest for a proper competitive procurement of renewable energy program. We usually begin from the Federal Energy Regulatory Commission's criteria that stem out of the Edgar decision. Now, the Edgar decision was not about renewable energy or renewable procurement, but it was about utility procurement and how you can ensure that a utility procures capacity fairly and equitably. And the criteria from that are explained further in a couple of additional FERC decisions, one having to do with Allegheny Energy, another I believe has to do with AEP, one having to do with Section 203, another with Section 205 of the Federal Power Act. Four basic criteria that they use and that we use in our evaluations. Transparency: the solicitation should be open, fair. Nobody should have a particular informational advantage. All aspects should be publicly declared, publicly available, aspects of the solicitation, that is. Bidders should all have equal access to the RFP materials. Second is definition. The product or products that you seek should be clearly defined, clearly and precisely defined, as well as giving people an idea of how much you want. If there are any changes in the product specification, those changes should be made available to everybody. And the RFP should not be written so as to exclude products that can fulfill your objectives. It should really relate directly to the need and objectives that the company has, the company and the regulator set. Third category is evaluation. You should use standardized evaluation criteria that can easily be applied to all bidders and all technologies. So the RFP should clearly specify price criteria. It should specify non-price criteria. It should specify whether bids are going to be evaluated on a standalone basis or a portfolio evaluation. I think we'll be talking later, or there are some other questions about portfolio evaluation where you see whether a set of bids can actually work together. The non-price criteria should specify the relative importance of each item. And the price criteria also should specify the way that various price components are combined, or that other components that are not automatically price-based are priced. One example that is used in some jurisdictions would be the value of renewable credit. Another example that is used in some places is an emissions value. Finally, the fourth category is oversight. An independent third party should be there to monitor the solicitation, design, administer as you wish, but certainly to provide a judgment as to the quality of the solicitation itself. The third party's decision-making should be independent of the utility, of its affiliates, and of all bidders. And they should be able to make a determination that the entire process is transparent and fair and resulted in a decision that was not influenced by any affiliate relationships. I'm going to turn it back to Martin now. Thank you.
Actually, I'm going to.
Oh, sorry.
I'm going to jump in, John. One of the things that's been a little unclear to us is Santee Cooper's legal ability to offer to self-procure, and if that is possible, it's potentially its interest in offering to self-procure, because that is one of the things that in some jurisdictions complicates these procurements quite a bit. So has that issue been resolved in some form or fashion, or is that an open topic?
I can't really answer that yet. Santee Cooper has not heretofore been under the regulation of the Public Service Commission, and so I'm not sure what their processes are going to be as far as bidding in on a CPRE program themselves.
So just to be clear, we have dealt with self-build options in many of these solicitations that we've been the independent evaluator for. It is one of the places, particularly to some of the independence points Jonathan was just making it toward the end, that are where it gets really important, because there's a lot of subtlety in that space. When that's not involved, things are much cleaner in a sense, if you will. So leave it at that. Martin, this one's coming your way. Do you recommend a weighted decision matrix, such as those used in an integrated resource plan?
Thank you, Derek. So I'm going to give the perspective from the procurement side. So there are multiple ways to...
Martin, could you sorry for the interruption. Could you back up? We missed a part of the sentence there that I think was you framing your response.
Sure, not a problem. Can you hear me now?
Yes.
I had a little bit of an internet access issue. Okay, great. Yeah, so I was going to say that I'm going to give the procurement perspective, and then I'm going to hand it over to Sarah to give the IRP weighting matrix perspective. But from my perspective, there are multiple ways to perform scoring. So one critical thing that we see often, especially to evaluate bidder quality, is doing first scoring on a minimum threshold. So basically this means mostly binary questions. Did they provide the technology that you're asking for? Is the size of the capacity the minimum size that you're asking for? do they have enough experience? Basically, yes or no questions, and we think that's a good way to screen out bids that might not.
Martin, I'm afraid you've frozen again right after screening out bids that I think you were going to say might not meet the requirements. We have lost Martin. Sarah, could you pick this one up?
Sure, I can. So just to quickly kind of backtrack where Martin was going on that, there are several ways to approach the scoring. So looking at a threshold, understanding how the weighted decision matrix would need to balance the qualitative and quantitative aspects of the full plan. And then a second approach may be sequential scoring, where that scores on something like a minimum threshold and understanding if the technology is viable or even eligible, having more sophisticated characteristics of the developer and what the facility would be offering. And we've seen those two used successfully under both methodologies. Understanding technology neutrality is a little complicated. Just knowing simple levelized cost of energy calculations for total energy produced might not easily just be divided by the total cost. And it doesn't take into account when the resource is producing energy and other aspects of the generation output. But when there are multiple technologies involved, we recommend looking into the production on 8760 basis and doing the modeling from that perspective, just to get a little bit more of analysis and understanding the hourly level and bringing in any additional capacity costs, and that could be a little bit difficult in illiquid markets. So in comparison to what I was going to discuss for IRP, is we really look at developing a scorecard based on the study design, the market parameters, study results, and then how the action plan will be executed. And so building the portfolio and understanding what would be preferred based on what the system demands and what it can handle. And so similarly, we would take an approach of understanding supply inputs, load forecast, demand aspects, and then consider the pricing forecasts as well and capacity benefits. So they do interrelate. We would probably, again, approach it similarly, and then kind of bringing it back to how the procurement design would actually run, if it would be one-to-one with how the preferred system portfolio is actually designed, say from their IRP process. And if anyone else wants to jump in to help clarify, happy to pass it on.
Yeah, thank you, Sarah. I can jump in here real quick before we get to the next one. You know, essentially, when we look at price versus non-price, you know, it tends to be weighted. Most evaluations we've seen tend to be weighted in favor of price. You know, typically sort of somewhere between, you know, 60 to 80% in favor of the economic indicators, and then the 20 to 30% of the overall score based on non-price scoring, and non-price scoring, you know, getting into developer experience and all things of that nature. Credit quality is another big one in terms of non-price scoring. So I can pause there to see if there's any questions from the commission regarding the weighted decision matrix.
I'll just add that with the advent of the IRA legislation, there's certainly a whole lot of zip code targeting analysis going on all around the industry, and we'll expect to see some of that be folded into your procurement here. And that goes to some of the locational issues that Charles and others were alluding to. Whether that's locational as in close to load, or locational as in jobs creation, or locational as in communities where we want to have additional jobs and economic development. So those are all you know, things that are routinely included in the non-price scoring. So with that, Charles, would you talk about experience in state-regulated energy markets such as South Carolina?
Yes, happy to. As you know, there is no organized independent energy market in South Carolina, similar to a PJM or a ERCOT or a CAISO type of energy market. We refer, a lot of times the South Carolina situation will be referred to as bilateral markets, and that is where utilities just contract directly with each other, with either with each other or with seller independent power producers to purchase their power on a bilateral sort of contract basis. We do have a lot of experience working in those types of markets. A good example would be the Pacific Core work up in both Washington and Oregon, working with the Oregon Commission staff there to independently evaluate Pacific Core's procurement. That is an example where there is no organized market such as CAISO or PJM, but the state does have jurisdiction and regulation over PACs, procurement, and other activities. And that's actually the case even in areas where there are in markets where there is an organized market, such as PJM or CAISO. Typically, the state still may not regulate those markets per se, but they're still regulating the utilities within those markets. And so that's an area where, yes, there may be an organized market, but the utilities themselves are still subject to the rules and regulations of the state commission, whatever commission has jurisdiction over those utilities. And so that's sort of a combined, both organized market, but yet still regulated process. And an example of that where we have a lot of experience would be our North Dakota work, working to advise the advocacy staff of the North Dakota Commission. They are regulating Xcel Energy's procurement, even though it's within the context of the wider MISO market at that point. So that's how we sort of see our experience working with state regulated entities, whether or not those entities are in an organized market. And the next question, does our firm have a best practice or standards list for competitive procurement? I think Jonathan covered a very similar question just a few minutes ago, and he was talking about the EDGAR criteria and transparency and definition, and also a defined evaluation process for how the utility is going to go about evaluating the bids that they come in. I think John did a good job of sort of covering those best practices. The final question, or at least not the final, but before I hand it over to Jonathan for the following question, the question: do we believe that Santee Cooper can act independently in organizing, managing, and evaluating a competitive procurement, or if it should be done via a third party? We did have that discussion a little bit earlier on this call. In this interview, we discussed, we're not aware of any reason why Santee Cooper could not do this. It gets to the level of sophistication and how familiar they are, how prepared they are to get perhaps a large number of bids, a larger number of bids than perhaps they were expecting. But in as much as the commission that has a consultant to help them oversee and evaluate the program design that Santee Cooper will be filing, I believe on November 1st, to the extent that if the consultant would find any issues, any reason to believe at that point that Santee Cooper is not prepared, we would consider that to be part of our mission to opine on whether or not Santee Cooper is prepared to do the procurement. But we would really need to see that proposed program design before we could make a full opinion and recommendation at that point, if that makes sense. I'll pause there if the commission has any other questions before we move on to Jonathan's next question here on modeling the bids themselves.
Charles, I'll jump in and just make the point that to try to tie a couple of threads together. As an example, assuming that Santee Cooper proposes to administer their solicitation themselves in their filing on November 1, we would likely expect to ask some questions of them about their prior solicitation, the 425. What was the volume of bids they received? What was the range of bids they received? That sort of thing, to understand the level of complexity they and Central dealt with in the prior solicitation, and be able to offer some judgment and advice to the commission based on that as to how comparable that is perhaps to the solicitation they'd now be undertaking. So with that, Jonathan, is there a particular model that should be used to understand the interaction between existing resources of a utility and different portfolios of bids?
Thank you, Derek. Martin already talked about decision matrices, for example. Decision matrices and spreadsheets can be used to evaluate an individual resource if you have a particular set of criteria against which you want to evaluate it. They can even be used to get some idea of how it interacts with the utility system if you already know, for example, in which hours the utility needs power or finds it most valuable. But to really get a good idea of the way that resources interact with the utility system, and in particular, the way that new resources will interact with each other, you need to use some sort of a simulation model. And this can also be important if you realize if you want to maintain a diverse base of resources. You don't want to get in the situation, for instance, they got into in Texas a number of years ago, where they had a large increase in renewable generating capacity, wind generating capacity in North Texas, which was subject to which was all subject to a loss of wind at the same time. Right? You want to make sure that you have a certain amount of diversity in your base. You would use a simulation tool or model that can compare portfolios of multiple different resources, typically a screening model or a production simulation model, which a production simulation model will take a group of resources, including the ones the utilities have already, and simulate when they're going to operate, how they're going to operate together, how much each is going to be dispatched, and how much that will cost. The difference between a production simulation model and a screening model is really generally one of scale or generally one of degree. Production simulation model tends to model time on an hourly basis, or finer, tends to have a more detailed representation of individual resources than a screening model will. And larger procurements or portfolios with more potential interactions will tend to use the production simulation models. Also, portfolios that need to consider reliability hour by hour. PA, for its own purposes, uses Aurora. We have used ProSim or Multisim in the past. Our consultants, our team members have used a number of other production simulation models, such as ProMod, ProScreen, which is a screening model. There are also other production simulation models or system simulation or screening models that have come on the market recently. Resolve is a model which is put out by a company called E3 in California, which is getting a lot of traction, especially in the West. Plexos is a model that is put out now, I believe, by Energy Exemplar. Interestingly enough, Plexos is the successor to a model called WEMSIM, which is a PA model that was developed for PA by the same guy that developed Plexos. So there's a lot of these different potential models, and really it's almost a matter of taste when you choose among them, but they're all better than the alternative, which is not to use one at all. Um, so it is also
John,
sorry. Yes.
John, would it be correct to say that primarily this is going to be what Santee Cooper currently uses in-house for their own purposes would be the tool that will be applied here, would be
In
likely
fact,
applied here?
I was going to go a little further than that, Derek, and to say it is quite likely that they would use the same model for evaluating bids that they used for their integrated resource planning. So the integrated resource plan is usually made based on the results of a model such as this that doesn't look at individual resources discretely in great detail, but looks at resource characteristics by category of resource, right? So they will say that you need so much renewables, so much else, given that your current resources are of this type. So, and they will put together a plan going forward. And then when you evaluate bids, you will evaluate them with respect to what you have now, as well as what you plan to do after this procurement, so that you will be able to respond to the future also. So, but they do tend to use the same type of model there for the IRP. That's one of the internal purposes for which they use a simulation model. Another internal purpose for which they might use a simulation model historically was fuel planning for coal-based utilities. We don't have that many coal, we don't have that much coal contracting anymore, but it's still around, still all over. But they often will use a different simulation model for fuel planning than what they use for resource planning. It is important, though, the scale that you use, especially if you are concerned about the reliability of your system, should be such that it recognizes the variability of unit availability, right? Because you don't want just to have enough capacity to meet your load. You want to make sure you have enough capacity to meet your load if some of it breaks. And you don't know what's going to break, and you know it's not all going to break at the same time, but you're going to have some times at which more units are out than others. So that's a criteria that generally comes into play with the data that goes into the model. This also helps you understand whether your portfolio is adequate. Sometimes utilities will use a separate model to count the amount of capacity that they buy and compare it to their need target. RTOs, regional transmission organizations, will often set counting rules for capacity so that you have to have a certain number of megawatts, and a megawatt of solar really only counts as 20% of a megawatt toward that target. A megawatt of wind counts as 10%. A megawatt of something else counts as some other percentage. So that's a simplified sort of capacity model. A utility that is not given that kind of accounting rule by an RTO or a regulator will use something more probabilistic that, again, considers the probabilities of unit outages when you need them in order to determine whether you have enough capacity. And that outage pattern has to take into account also the natural pattern of the energy of the energy source, the fuel source that the generator uses. For example, for a solar unit, they're not going to be very reliable at night. They're not going to be there at night. Wind units, you have to worry about times when the wind typically blows, times when it doesn't blow.
All of which goes to show why defining the model and models that will be used in the evaluation process is an essential part of a procurement plan.
Exactly. Thank you. Thank you.
I just want to ask you a question, if I could. Several times today we've used the word, or y'all have used the word portfolio, and I haven't been through a CPRE process before, but I'm tend to associate portfolio with an IRP. Are there portfolios in a CPRE as well? Or
oftentimes,
okay.
Oftentimes, not always, but often. The portfolio in the IRP is a big portfolio. It's the utility's entire portfolio of resources. The portfolio in a CPRE, in a competitive procurement, is a smaller portfolio. because it's only the set of new bids, right? So you want to
Okay.
evaluate that portfolio in the context, though, of the utility's larger portfolio, what the utility's already going to have,
Okay.
right? But
That helps. Thank you very much.
sure. Um, the next question, how do you incorporate factors such as resilience, equity, and economic development into a competitive procurement of renewable energy process? I'll try to be a little briefer here. Resilience often means the ability to withstand extreme weather events. And there are two ways to look at this. You can look at it through the context of modeling, the reliability model that I talked about earlier, trying to make sure that you have enough capacity to withstand these events, to serve load despite these events. It's trying to make sure you have enough diversification of your capacity in case of a localized event, or by setting the standards for the resources that you allow to bid, right? So it is said that the issues they had in Texas in February of 2020 had to do with the standards that were set for some of the resources that the utilities had acquired there. Okay, and I don't know if that's what it was for sure, but it is something one can set as an eligibility criterion for bidders, right? Economic development is important in many states. The state will, for instance, establish an economic opportunity zone, and one can provide a credit to bids, an advantage to bids in the scoring process, or a cost, not a cost adder, but a cost subtractor they will use sometimes in order to incentivize bids in those economic opportunity zones. Economic development can mean a number of other things. It can mean trying to identify the jobs impact of different bids, which we don't often see in resource procurement, in competitive resource procurement. More when somebody has a particular project they want to push, they'll tell you, they'll do some modeling to tell you what the jobs or the other economic benefits of a particular resource are. And they'll use another type of complex simulation model for that, an economic input-output model such as JEDI. And I don't know what JEDI stands for, I'm sorry, but when I've been in situations that used it, somebody else did it. So, but I'm familiar with, we are familiar with that category of models. But economic development can have a number of other meanings, a number of other things that translate into bid criterion. In some states, they will insist that bidders use union labor or employ a specifically diverse workforce or have filing requirements on resource diversity, that there are some wage requirements, whatever. This all depends on the jurisdiction. Equity is another factor that is often incorporated now. Actually, the state of Washington makes it a requirement legislatively to consider equity. This is a newer sort of thing, but but procurements do sometimes attempt to set criteria that will increase equity, which can be set asides for particular areas or set asides against particular areas. And that's when they think there's an area that has already been significantly impacted by pollution, by emissions, by other things. They will try not to cite a noxious facility there, if any of these solar facilities can be considered noxious. There are disadvantaged communities where they will actually sometimes want to cite facilities. That's again an economic development as well as an equity impact in order to spread things around. It's important, though, to define all this stuff up front in order to make it more transparent and objective. A number of these reasons also tend to encourage reuse of existing sites. Building at the site of a shuttered coal plant is good for it's good for economic development in the sense of preserving the jobs there. And if building there encourages the coal plant to shutter and the local community as long as they get the jobs, but as long as they get the additional jobs, may see that as an equity benefit or an environment, what they call an environmental justice benefit, um, because they don't have as much local emissions. But this all varies from jurisdiction to jurisdiction, and these are really decisions that the regulatory process needs to participate in and make sure are set correctly. They need to be included upfront in the scoring and bid eligibility rules. And I'm going to turn it back over to Derek now, unless you have other questions for me.
Thanks, John. Moving along, what will be the appropriate time for a competitive procurement to take place? Charles, overall time frame from the commission order that the Madam Chair indicated would kick this process off?
Yeah, I mean, at the end of the day, the appropriate time to conduct the procurement really depends on when you need the resources and why. In terms of if you're looking for new development resources, you clearly need the utility would need to allow for sufficient time for them to conduct the solicitation, receive the bids, make the selection, and then at that point give the developer enough time to get the resource permitted, developed, constructed, and online in time for some future date where you need that energy or capacity for. Typically, depending on the circumstances involved, we see procurements sort of trying to hit about a 2-year mark for after the selection, from the time they are given signing a contract to proceed, about 2 years to become online. Obviously, that can vary considerably depending on permitting requirements and other issues. But there's a third issue involved in terms of whether or not the facilities have an interconnection place and have an interconnection study that's already been completed. It's difficult to conduct the full evaluation without knowing what type of interconnection costs resources may have or may need before they can come online. So typically what we will see is utilities will make the selection of a facility contingent upon knowing its interconnection costs, or better yet, having those interconnection costs studies be a bid requirement, that they would need to have that study done before they can even bid into the solicitation. And it's important to note here, one final note, that having a position in the interconnection queue is not the same as having an interconnection study done, right? They can be in the queue, but if they don't have a completed interconnection study yet, they may have a place in line, but they don't quite know yet what the interconnection costs are going to be. And it's nearly impossible to make a selection and award a contract without knowing what that interconnection cost is going to be, at least having had it studied and a firm estimate of that cost. Again, it's sort of difficult to specify an exact time, but certainly it's very difficult to do something sooner than about 2 years from the time a developer is given notice to proceed to the time that they can come online. And it often could be longer depending on any interconnection study issues,
Charles,
or other issues.
Charles,
Yes.
Can you back us up from what can you add to that time frame, what it's going to take to get from approved procurement process I use that word with quotes around it, to developers' notice to proceed? What's that? What do you think that time frame reasonably is?
So assuming that Santa Cooper, or assuming the commission gives an order saying, yes, we agree with Santa Cooper's procurement plan, um, you know, typically the solicitation itself can occur anywhere from 3 to 9 months, depending on the complexity and on the number of bids. And so if Santa Cooper was given the green light, they're going to go do their solicitation. That's going to take 3 to 9 months typically. And then after that, it would be another 2 years to the time the developer could get online.
Thank you.
And is that helpful for the commission? I feel like that was a bit of a wide-ranging answer to a fairly broad question. Hopefully that's helpful, but happy to take any questions on that point.
Hearing none, why don't we move on to the question of how do distributed energy resource programs play in this? Can the two programs exist in balance? Jonathan, maybe a crisp answer to this one, just conscious of everyone's time.
Yeah, this is a lot tighter. This is a lot a much better control, much different type of question. Assuming that you have a distributed energy resource program, which is one that is trying to have the utilities subsidize or encourage the development of distributed resources such as rooftop solar, how can that interact with your competitive procurement? Well, first of all, it can defer some of the need to the procurement. If you have a specific amount of need set aside for the distributed energy resource program, you take that out of the procurement in order to make sure that you don't accidentally procure too many resources. Secondly, you can have the distributed energy program integrated with the procurement in the sense that you have these distributed resources bidding into the renewable procurement. It's a little bit complicated because distributed resources tend to be on a much smaller scale than the utility scale resources, which would dominate a competitive procurement, but it can be done. Finally, you can design the procurement so that distributed resources can bid in as an aggregation. Either the program itself bids in as an aggregation, or more commonly, independent aggregators will bid in to build or site distributed resources and have them supply energy to the utility in front of the meter or even behind the meter. And there are programs like this across the country. For example, in Hawaii has a very large distributed resource program like this. And the Federal Energy Regulatory Commission has taken steps to encourage the consideration of such programs in RTO markets. South Carolina is not an RTO market, but many of the considerations that led the FERC to encourage these DERs organized in RTO markets may also be at play in South Carolina. Derek, back to you.
And I guess I'll just add, in the context of Santee Cooper, obviously the Central co-op, the members of Central, may, or to the extent they have programs that are DER encouraging programs, that needs to be factored into here as well. So that's the fact that Central is the primary purchaser from Santee Cooper, and then there's another level of distribution cooperatives underneath that are just small compounding issues we need to take into account in dealing with DERs to make sure we end up with the amount that everybody wants. Charles, could you again talk briefly about the characteristics of generation that is encouraged under a competitive procurement of renewable energy program?
Sure, happy to. Essentially, when we talk about the characteristics, the first thing we think of when we think of renewable energy is having that renewable characteristic typically we're talking about wind and solar facilities. There are other forms of renewable, geothermal, things of that nature, but I would expect that Santa Cooper is going to be receiving some types of wind and solar bids. And when we think about that, typically there are renewable energy certificates that come along with those types of renewable facilities, and those can be used to satisfy either any type of renewable energy mandate that may be in place, or often can be used by corporations, can be sold by the developer if the utility doesn't need them, for corporations that are looking to green up their power supply through the use of renewable energy certificates. I would say for Santa Cooper, the biggest issue is going to be, in terms of the characteristics, it's going to be how well does this generation line up with Santa Cooper's peak demands. Lots of times, as John mentioned earlier, the firm capacity, the amount of capacity that's going to be available from that resource at the times of Santa Cooper's times of peak demand, that's going to be one of the issues here, because as we know from our work looking at South Carolina previously, Santa Cooper's demand tends to peak in the wintertime, and in particularly in the morning times. A large number of their peak hours are in the early morning hours in the wintertime, and there's very little solar available at that time. We may see one metric that we've used in the past is something on the order of 4 to 5% of the solar generation that is on the system. 4 to 5%, single digit four, is going to be available, putting power onto the system during a large number of Santa Cooper's peak hours. So what that really means is that as you're procuring a solar resource, you're essentially not getting very much, little to no peak support, no peak demand support at that time, but you are getting all the energy throughout the day that the facility will provide. So it sort of depends how much how much Santa Cooper needs the solar or the renewable resources to be aligned with their peak. That's one of the key determinants, and it's going to be a key determinant in the evaluation, I would expect. Wind wind has a higher matchup alignment with Santa Cooper's peak, but it's still not a very high alignment, and it depends on geography, and it depends on the resource that would be bid in. So I would expect that Santa Cooper would also be seeing a number of paired solar plus storage and wind plus storage bids, perhaps more likely on the solar side than the wind side. And what that would do is it would allow for, and that storage would be behind the meter of the renewable facility, and that would allow for that storage unit to essentially take energy from the facility during off-peak times, off of the peak demand, to allow the facility to provide that energy during times of peak demand. And if we see those types of bids, that's going to be much more valuable to Santa Cooper, because that would allow them to have all of this renewable generation, but also be providing it during times of peak demand for Santa Cooper. To me, that's one of the largest characteristics that's going to be in play here, is that ratio of total energy versus the amount that's going to be available during times of peak demand, and be able to provide that reliability during those times.
So when we think about, thank you, Charles. So when we think about weightings and criterion, the complications and a and an organization that is relatively early in its potential future migration toward a cleaner power supply, it's possible that the plan they file in November will be simply look for renewable energy. That is one set of documents that could come in. An alternative is it may be more encouraging for renewables plus storage, which is a much more common thing that we see in many other jurisdictions at this point. Exploring which, depending on where Santee Cooper's proposed plan comes out on that, we're going to have to dig into that to understand whether they have made what to us look like good choices and offer some feedback offer some perspective to the commission and recommendations to the commission on those points. So this question of, are we just looking for renewables, or are we looking for renewables with storage that therefore has a bit of a different load shape and generation characteristic to it, is a really timely question.
Chair Belser?
Commissioner Williams.
Thank you. I have a question for the team before we leave this segment. I'm looking at page 11 on your proposal, and I am going to ask this, but I'm very open to a submittal that you guys would make on Thursday that might just augment this. The section that's interested me is the section that focuses on independent evaluator, monitor, auditor experience. And you all have talked about these significantly, but I have to confess, in being new to listening to some of this, and especially some of these energy providers, that I may not have followed you as well as I wanted to. So here's what I'm interested in, if this is doable, would be to see what kind of megawatts were associated with each of the utilities that are in the left-hand column, and what your experience was, what your role was in each of those, and maybe generally, I mean, this is all just one line in this chart, what the results were. Was it adopted? Was it useful? Did it end for some reason without being implemented? So I'm open to listening to you all now, kind of fill that out, but I'm also very willing, if you're interested in just creating a little bit bigger chart that to me relates very much to the experience that you've had, but helps us to really just really capture it well.
Commissioner, why don't we just take that as a to-do, and we will take the information on page 11, expand it in the way you just requested, and file it by Thursday.
That is absolutely fine with me. And just for clarification, I'm only talking about those 7 or so lines from PacifiCorp down to New York Power Authority.
Perfect. Thank you for the question.
Thank you.
If I've got the right spot here, the next question is about reading pleadings and discovery and pre-filed testimony, and talking about how our team's experience in similar situations relates to schedule and how we go about undertaking this work. Jim, do you want to take that one?
Sure. So I think we've had many references to North Dakota Public Service Commission, to the work that we've done as independent evaluator, but we also work on behalf of the New York Department of Public Service in submitting expert reports to the New York Public Service Commission regarding resources acquisition and infrastructure, although primarily on the gas side. So a couple things about our process competency. A few things is, we are used to procedural schedules and keep track of schedules and file and all these proceedings on schedule. One thing that we take particular note of is in discovery and being aware of the turnaround, whether you have a 10-day rule or what the rule is for the proceeding, to make sure that we're very, reviewing pre-filed testimony or data responses on a very timely basis, so that we can get our, any additional data responses in time to allow us to do our report and get everything done on the procedural schedule. So keeping track of timing is absolutely critical in terms of reading and pleadings and pre-filed testimony. Typically, what we want to do is have multiple people read it, and then what we do is after multiple people have read it, we get together and discuss it, identify the key issues that we may need more information on, or issues that we want to make sure that we address in our reports. In terms of listening, which I think gets into the next question, listening is critical. I think in a proceeding like this, listening is usually towards the end, that you've used pre-filed testimony and now you're at the hearing. A couple comments I'd say about this is listening requires 100% attention, and so the proceeding may go on for a while, but the words come and go pretty quickly. I think it's absolutely critical that I have someone, or that there's a support team, so that someone can be looking something up or looking for numbers while the person who is actively responsible for asking questions and in real time stays focused on the proceeding. So if I can maybe just go on to the second question, which I think is very similar, Derek, in terms of process competency. As I said, I think the active listening is really going to be towards the end of this process, but a lot of the observing testimony will happen up front or in the pre-filed, and we'll make sure we do that on a timely basis. We're very experienced in providing testimony and providing a clear written report. The internal strategy that we always take is to have a separate peer review of any report or testimony that we file. I think it's very helpful to have someone who's not, absorbed on a day-to-day basis in the project to read the testimony, read the report, to make sure that that makes sense from a third party. They may even go to what Derek was talking about earlier. A fair amount of acronyms are used, but just to make sure that the language is very clear. Just as we would expect that any other party filing testimony has clear logic and clear work papers in the process of developing testimony, very careful about attention to details. We like to use lots of references within the testimony so it doesn't create data responses afterwards. So if we're citing something, if we're stating a fact, there's a clear cite to it. And in the process of developing testimony, we want to make sure that we develop clear work papers that have also been checked by an independent person on the team to make sure that there are no errors in that. So I think that pretty much answers those questions.
Thank you, Jim. We're on the home stretch, honest. How's your team equipped to undertake this work given the commission's schedule? The bottom line is your schedule. It's your schedule. Our job is to make it happen, and that's simply what we do as a matter of course. Our energy team here in the States is about 125 folks. You're seeing the subset that we would look to dedicate to this, that is our independent evaluator, monitor, administrator team largely. But we have other resources we can draw on, and we obviously do some workload balancing in the background to make all our clients' schedules work out. So we are a sizable firm. We bring that experience. We bring the flexibility to make some of those things happen. In terms of the fundamentals of helping South Carolina get started, move down a good path in renewable energy, I had the opportunity more than a decade ago to spend 6 or 7 years working extensively in Hawaii. I can tell you from the East Coast, Hawaii is a long ways away, and it wasn't really a fun commute. But the reason I went there is that they were, because of high oil prices in the immediate post-Fukushima time period, they were experiencing renewables being economic long before we would see that on the mainland here. And so the opportunity to be a part of that, to learn, to understand the issues that evolved there has been fantastic for me personally and for a number of people on our team. When you expand that across our whole team, we're talking about a firm that's worked on more than 100 generation projects just over the last decade. Generation projects of all shapes and sizes, all fuel sources, many renewables, but certainly also some nuclear and fossil programs as well. So we've modeled those. We understand how they interact with each other. To the portfolio question, we understand what they do as a portfolio, what the individual piece parts contribute to that portfolio, what some of the risks to that are. Whether it's Winter Storm Uri in Texas or Hurricane Maria in Puerto Rico 5 years ago when a solar project after that hurricane looked like a pile of tinfoil. We've been through those things, and we know what they do, and we bring that experience to this table. And our goal is to be the leader in this to help be the leading advisor to this transformation. And we really want to get South Carolina started on a good procurement path here the first time out of the gate. So that's a bit of the pitch. Jim, what have I left out about how we're going to meet the commission schedule?
No, I think you have that covered well. Do you want me to address the next question on process competency?
Sure.
So just as I said, it was important in asking data in discovery, to say specifically what you want. For better or for worse, my training in this is, in responding to discovery, is to answer the question that's been asked. Don't go on and think about what question they might have asked. Clearly, if there's misunderstandings or something, if the inquiry indicates that someone doesn't understand, you want to correct that, but try to stick to responding to the question that's been asked. Being deposed, myself and others on the team, we all have experience with that. Been in depositions that last a full day. That just requires a fair amount of fortitude and making sure that one is patient and doesn't get into a mode of wanting to be done, so that all the answers are very careful. So whatever might be moved onto the record is what you want to be moved on the record. Being cross-examined, I think the last time I was cross-examined was about 2 weeks ago on a tax case in Louisiana. Again, it's very important to listen carefully. We have a lot of experience with that. Listen carefully to the question that's being asked, respond to the question, and of course, being very responsive to the commissioners. So with that, Derek, I think I will turn it back over to you.
Thank you, Jim. A logical question that had come up actually in the portfolio context a little earlier is that the PSC is in the process of hiring a consultant to work on the IRP. We were pleased to be considered for that as well. The question here is discuss what advantages there may be to the Public Service Commission to use the same or a different consultant for this particular task. Sarah, do you want to talk about that?
Sure. Thanks for that. We feel it would be an advantage and certainly would not be an impediment to have the same consultant support both engagements. The main advantage would be that there would be a shared understanding of Sandy Cooper's generation portfolio and how their IRP and preferred portfolio had evolved throughout that process. So there would certainly be synergy across the IRP and procurement teams in our case. Likely have the same team members as well, and due to the nature of the scheduling for these two engagements, they wouldn't overlap significantly, as the next IRP cycle wouldn't be set for approval until May of next year, and this engagement would likely start earlier this fall, later this year. We feel like there would be a lot of balance across both teams as well as both engagements. And then just to take on the next question as well as we move along, can the prospective consultant review Sandy Cooper's competitive procurement of renewable energy programs and render an opinion on whether the work was performed correctly? We feel that the consultant or PA, if awarded this engagement, could and we could provide recommendation in a final report or in rendering an opinion of whether the work was performed either successfully or in meeting the statutory requirements of section 58-31-227, understanding that everything would be communicated through the docket proceedings. And as mentioned by the commission earlier, we don't know exactly how there would be a decision process as an end result of this procurement plan, whether it be an approval, modification, rejection, etc. But understanding that we will adhere to what is required in all commission decisions, policies, directives, orders, and statutes, and ensure that that the process has flowed in a way that meets all of those guidelines.
I have a question. While we think we know that the schedule is of Santee Cooper filing around November 1st and then their IRP being filed, I think it's in May of 2023. If for some reason we did not conclude the CPRE program prior to the filing of the IRP and it extended longer than might be anticipated, would that create a hardship?
No.
Oh, I'm sorry.
So, sorry, Sarah, I jumped in just to say no. That, those things happen all the time. It's just the nature of the business. And again, I think one of the things we bring to this is a scale of team that we're not going to move people off of either engagement, for example, for the commission, but we have some flexibility to not have people working on other things that and move things around. So that's part of having 125 colleagues here in the States that are all experts in this general field. Gives us a lot of tools.
Okay, thank you.
Charles, you're I think at the end of the list here. So, how would this prospective consultant conduct the analysis of Santee Cooper's competitive procurement program? For example, financial modeling and technical analysis and things. You can maybe give us a brief view of that.
Sure. I expect I'm on a quick timer here, Derek. For us, we kind of view it as two different things. There's the evaluation of the program that they are going to file and the description of that. That would really be more of an evaluation, and we would look at it in terms of all the things that we've talked about today. Is the RFP clear and concise? Do they have a transparent evaluation methodology? What is their plan for stakeholder involvement, if any? All of those types of things, and we will evaluate that program and file our report with the commission to give our opinion on whether or not it's a worthwhile program, and if it meets the rules and policies that South Carolina has in place. Should it, at some point, if the ask were to actually do a third-party evaluation of Santee Cooper's bids, which we understand is not a part of this initial scope, this initial ask, we would again use our models, as Jonathan discussed, to evaluate the bids, to run the program if that was needed, if that was requested. We certainly could provide an overview of those types of those types of steps. If the engagement were to go in that direction, we can provide that in our written responses that we'll be providing by Thursday. But we are clear that this initial scope, this initial phase, is to just evaluate the program design that they are going to be filing, that Santee Cooper is going to be filing, and we will do it according to all of the topics that we've discussed today, if that makes sense. Happy to ask or take any other further questions on that, recognizing that we're pretty much up on time.
I just add in the financial weighting category, for example, we talk some about non-price weightings or qualitative assessment weightings. In evaluating the program, we may well do some modeling of how much that can swing things to provide some perspective on are they material or not, are the weightings reasonable or not, those kinds of things to judge where that comes out. Back to some of the perspective Charles had provided earlier of sort of where price versus non-price criteria normally fall.
Thank you. We should certainly appreciate the presentation and the detail that you've provided. It's certainly been comprehensive. Commissioners, any questions at this point? Hearing none, I do want to remind you, Mr. Hasbrook, we need a final conflicts letter by Thursday. I think it's September 22nd, no later than 3 p.m. And you said that you would get the written responses to the questions to us as well.
We will do those things. We will also provide the information that
Commissioner Williams asked for.
Yes.
And that can be at the same time as the conflict letter on Thursday.
Perfect.
Thank you. Thank y'all very much for your submittal, your presentations today. Appreciate your team being on. And with that, we will adjourn this interview. Thank you.
Thank you.